Alyssa Mercante's lawyers have filed a motion to deny my motion to hold off on discovery until the case is even heard. And I know that's kind of a mouthful of words, but basically in layman's terms is we're right now in the situation of waiting for the judge, the Honorable Margot K. Brody, to let us know if they are going to hear the case or if it's going to be dismissed with or without prejudice or whatever the hell they're going to decide with it. So we're in kind of a holding pattern right now. All the work has been done back and forth with everything. We finally got to the point where we're just waiting for the judge. And sure as shit, Alyssa's lawyers are coming in to say, hey, while we're waiting for the judge, why don't we start discovery now? And we're like, why the hell would we do that? Like, there's no logical reason to start discovery before a judge even wants to hear the case, because it may, and I would like to think likely will, be tossed out for multiple reasons, most likely being jurisdiction. But I mean, the Constitution kind of runs against it too, alongside a slew of other things. But for whatever reason, Alyssa and her lawyers seem to want to push for discovery to happen right away. And I really can't help but think that the reason why they'd be doing that is because they know that this case may not be heard. And that being the case, they want to try to use this as an opportunity to get any information against me that they can to potentially, allegedly, maybe, I don't know, accidentally leak out in the future after this all goes away to make me look bad, hold against me, or what I'm even more concerned about, because like I said, I don't have anything that I'm worried about, connections that I have, people I've spoken to, conversations I've had. They want all the information. They want to know everything about everyone. It's very, very concerning. So while we were in a holding pattern waiting, they made this full court press to be like, no, we want discovery. And I even had a conversation with Ron about a month and a half ago about this, when he's like, hey, they mentioned they might want to start discovery. What do you think about that? I was like, why would I want to do that right now? And he's like, yeah, that's the same I feel about it. Just want to throw it at you to see what you thought. I was like, look, I don't want to know anything about this bitch. I don't. Like, I want her out of my life. She's crazy. She's a stage 5 clinger. She keeps coming at me every single day, it seems like. And I literally do not want information on her. I don't want discovery. I don't want any of this. I want her to go away. Go away. Just go. Drop the case. Go away. What the hell even? I don't even know what you're suing me for still. You keep saying harassment. What harassment? If anything, you've been harassing me, Alyssa, the entire time. Ironic, I know. But yes, how the turntables. Anyways, I said the only reason they are so aggressively rushing to get discovery approved right now is not because it is necessary for the case itself. No, it's because they want access to my personal information and the people I have associated with, so they can dox, intimidate, and weaponize that information against me. This is not speculation. Alyssa has already doxed me in her filing of this case. It's beyond obvious when you look at how little effort they put into actually justifying this request. They barely even address the legal standard for stay, instead focusing on their hunger to dig deeper into my life. This is not how discovery is supposed to work. Discovery exists for the purpose of exchanging relevant evidence after a judge has determined there is even a valid case to be heard. That has not even happened yet. The judge hasn't even ruled on whether the case should proceed. And yet here they are trying to force discovery early. That alone tells you everything you need to know about their true intentions in all of this. They are not acting in good faith. They are not seeking truth. They are seeking to harass, intimidate, and destroy. When you strip away all the legal BS, this lawsuit was never about the claims Alyssa pretended to make. It was always about gaining the ability to pry into my private life. It was always about digging for names and connections they could use to expose and use as weapons. They want to create fear, to silence and to punish. That is why I call this lawsuit frivolous, because it is being used as a tool of manipulation rather than justice. Further proof of what I've been saying all along. These are not people who want fairness or accountability. These are evil manipulators who abuse the legal system to get what they cannot achieve honestly. They file lawsuits not to win in court, but to open the door to discovery and use that process as a weapon. They want to turn the system itself into a tool for harassment, which I know, again, ironic coming from the person suing me for harassment, but many things that I've seen, if not all, have been straight up projection coming out of Alyssa Mercante the entire time. So of course it's on brand. The public needs to understand this fight is way bigger than just me alone. If they can abuse discovery against me, they will abuse it against anyone who dares to speak out or challenge them. This is why this matters. That is why it must be called out for what it really is. Evil, manipulative, and destructive. And most of all, on brand. And I CC'd Ron Coleman with it. And this is the letter that came from Alyssa's lawyers. And here is the official one over here. Let me bring this up here. The Cameron Unk and Sonaker Klein, counselors at law. And they said, Your Honor, my firm with co-counsel represents plaintiff in the case above. I write in response to defendant's motion or to stay discovery. As set out below, the court should deny the motion. A discovery stay, even when sought to accommodate weighty rights, like those implicated in the Fifth Amendment, is an extraordinary remedy. And the person seeking a stay bears the burden of establishing its need. It is they haven't even decided if they're going to hear the case yet. Why the fuck would they let you do discovery right now? That makes no sense at all. Just thinking of this logically. It is black letter law that discovery should not be routinely stayed simply on the basis that a motion to dismiss has been filed. But that is essentially all defendant offers. He barely discusses anything specific to the case and relies almost entirely on the supposed strength of the motion to dismiss. Yes, because this lawsuit is completely frivolous. It is a joke. It is actually harassment against me. So yes, that is all Ron Coleman needs to tell you. Since he is wrong about that factor, which that is wild to say. that right there is an opinion. Yeah, I don't know if you're allowed to say that in these, but okay. The motion should be denied. Argument. Defendant has not carried his burden to show good cause for a stay. They talk about all this other, what's happened in other lawsuits, blah, 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 great stuff. And then the first two factors, disfavor or a stay or a neutral, defendant correctly identifies the three factors, but essentially does not commit after that on either the breadth or discovery of prejudice. That is particularly significant. Again, I could read through all of this, but just cut through the meat of it and say, this is a frivolous lawsuit that got thrown at me. We are requesting, not that it just gets thrown out, but with the SLAPP as well to be a part of it for reparations for me for dealing with this. And we're saying this is such a ridiculous case that there is no way in hell we should give you information right now before the judge even decides if it's worth giving information for. This is the definition of insanity right now. This is crazy to me. B, there are no substantial reasons in support of a dismissal, and defendant essentially concedes. Skewing the first two factors, defendant argues that he makes a strong showing the plaintiff's claims are unmeritorious. They are. Welcome. Whatever you have to say after this does not matter because the court has not heard the case yet. So we would like to wait for the judge to say, yes, it does have merit. And then, okay, I guess discovery is what's happening now. Guess we'll have to do that. But ain't no way, no how, no hell that we are doing that before that, because I am confident that that is not what's going to be happening here. I'd like to think I'm right about that, but you never know with the judicial system these days. They continue talking about the defendant declares that he demonstrated in his motion to dismiss that all the claims sounded defamation, but ignores the black letter rule that where the alleged harm suffered by, you don't even have the jurisdiction to do this lawsuit in the first place. So all this other shit that you're throwing out, what if it gets thrown out on a jurisdiction basis? Then everything you're fighting here doesn't even matter. It doesn't even matter. I would argue even if it doesn't get thrown out for jurisdiction, this still doesn't matter. But I'm just saying there's so many things that they're fighting up against. And I would almost argue that Alyssa deep down realizes that. I think subconsciously, I don't think she actually consciously realizes it because she dropped the lawsuit and walk away from it if she did. I think subconsciously, that's why she's dealing with such inner turmoil right now, is because everything in her is telling her, you don't have anything right now. And to everyone out there, you look like a complete idiot. And the further you push this, the worse it's getting for you. And because of that, it's making you very frustrated and you're starting to lash out. You're starting to leave X. You're starting to cry harassment on any little thing that happens when anyone talks about what you said. Like, you post something on the public forum, people will discuss it as a public figure that you are. And now that you're moving forward with the lawsuit, yes, people will be talking about things that you say, especially relating to the lawsuit. On top of that, the things that you're saying just on your streams alone is bad enough. You pile that on top of everything else. It's insane that it's even been to this point. Though defendant raises the state procedural rule that an anti-SLAPP motion stays discovery, he seems to acknowledge that the rule does not apply under. No, he definitely does not do that, but okay. Plus, he does not cite any in-circuit cases. His policy argument that the same discretionary considerations that usually govern a motion for stay discovery incorporate a stay of anti-SLAPP law has been rejected by a second court. The idea that more stringent requirement for this is, by the way, I'm no lawyer, but if I were a judge reading this, I'm just cutting through the bullshit. I'm like, what the fuck are you? What's your point? Why do you want this so bad? That would be my question. Why do you want discovery so bad before you know the case is being heard? That would be a question I would love to have answered. What's your rush? If you're so confident in your case, Alyssa, why do you want discovery right now? That's the only question I have for you. The question that you will never answer, because we all know what the answer is. And with that, I will leave that one there.